Le tribunal Vous pouvez vous asseoir.
You may be seated.
J'ouvre l'audience de la Chambre d'appel du tribunal pénal.
I declare the session of the Appeals Chamber of the International Criminal Tribunal for Rwanda open. Let me start off by saying good morning to Mr. Karera, to counsel, the representatives of the prosecutor, and to the interpreters and support staff.
Madame le greffier d'audience, veuillez annoncer l'affaire.
Registry, could you announce the case? Thank you, Mr. President. The Appeals Chamber of the International Criminal Tribunal for Rwanda, composed of Judges Fausto Pokar presiding, Mohamed Shahabuddin, Mehmet Gani, Liu Daquin, and Theodore Meron, is sitting this Monday, 2nd February 2009, in open session for the delivery of the appeal judgment in the matter of the prosecutor versus François Karera, case number ICTR-0174A. Thank you, Mr. President. I thank you. Mr. Karera, can you hear and understand clearly the interpretation? Yes, thank you. I will now ask the parties to introduce themselves, starting with the defense. Thank you. Good morning. My name is Karera Merchaud. I'm a lawyer in Montreal, and I am representing Mr. Karera's lead counsel. Thank you. Prosecution.
Good morning, Your Honors. My name is Alex Obote Odora. I appear for the prosecution with my colleagues Dior Fall, Senior Appeals Counsel, François Zinzorera, Appeals Counsel, and Beatrice Chapao, Assistant Appeals Counsel. Thank you, Your Honor.
Merci.
Thank you. In accordance with the scheduling order of the 4th of December 2008, today the Appeals Chamber will deliver judgment in the matter of the prosecutor versus François Karera. Following the habit of the tribunal, I'm not giving the exact text apart from the introductory section. So I am going to summarize the issues in the appeals and come out with the conclusions. Let me underscore that this summary is not part of the judgment, and that the only text that is authentic will be the complete judgment, and a copy will be distributed to the parties at the end of this session. Since it was written in English, and in order to reflect the text, the summary will be read in English. The French translation of the judgment will be available immediately after the judgment, and the translation of the judgment itself will be done subsequently.
Now let me come to the background of the decision. The appellant, François Karera, was born in 1938 in Hura sector, Musasa commune, Kigali prefecture. For 15 years, he was the burgomaster of Nyarugenge commune in Kigali-ville prefecture. On 9 November 1990, the appellant was appointed sub-prefect in Kigali prefecture, and on or around 17 April 1994, he was appointed by the interim government as prefect of Kigali prefecture. The appellant was tried on the basis of an amended indictment dated 19 December 2005, which charged him with individual criminal responsibility under 4 counts: genocide, count 1, complicity in genocide, count 2, extermination as a crime against humanity, count 3, and murder as a crime against humanity, count 4. He was additionally charged with superior responsibility under counts 1, 3, and 4. The amended indictment related to alleged attacks against and the murder of Tutsis. First, in the Nyabirambo sector in Nyarugenge commune of Kigali-ville prefecture. Second, in Rusashi commune in Kigali prefecture. And finally, at Ntarama church in Kigali prefecture. The trial chamber found the appellant guilty under Article 6.1 of the Statute of the Tribunal of genocide and extermination and murder as crimes against humanity. The trial chamber acquitted the appellant of the alternative charge of complicity in genocide in light of his conviction for genocide. It imposed a single sentence of imprisonment for the remainder of the appellant's life. The appellant presented 12 grounds of appeal challenging his convictions and his sentence. He requested the appeal chamber to overturn his convictions and to order his release. In the alternative, he requested the appeal chamber to order a retrial or, as a further alternative, to quash his life sentence and substitute it with a more appropriate sentence. In his brief, the appellant dropped his 9th ground of appeal, which accordingly has not been addressed by the appeals chamber. The appeal chamber heard oral arguments regarding this appeal on 28 August 2008. Having considered the written and oral submissions of the parties, the appeal chamber hereby renders its judgment. I will now address each of the appellant's grounds of appeal. However, I will deal with ground 1, part of ground 2, and ground 7 together, as they all relate to events in Rusashi commune. For the purpose of this summary, the appeal chamber will also address grounds 5 and 10 in part together, since both relate to the appellant's alleged involvement in a campaign to kill Tutsi in Nyamirambo sector. However, these grounds are addressed separately in the judgment itself. In his second ground of appeal, the appellant submits that in its assessment of the evidence, the trial chamber committed numerous errors of law that invalidate the trial judgment and made erroneous factual findings, occasioning a miscarriage of justice. Specifically, he contends that the trial chamber erred by applying incorrect standards of law in its assessment of his testimony and in considering conflicting, hearsay, circumstantial, and uncorroborated evidence. He further alleges several errors related to the trial chamber's conduct of a site visit. For the reasons given in the judgment, the appeal chamber finds that the appellant has failed to show that the trial chamber made general errors of law and fact in assessing the evidence. With regard to the site visit conducted by the trial chamber, the appellant alleges that the trial chamber erred in law by failing, first, to keep records and produce a report of the site visit. Second, to provide a reasoned opinion in relation to observations it made at the site visit. And third, to provide the appellant with an opportunity to present a full defense in relation to these factual findings. The appellant further alleges that the trial chamber erred, in fact, by making factual findings which do not take into account, and in some instances are contrary to, both the observations made by the trial chamber during the site visit and the submissions of the parties that were subsequently made in relation to these observations. The appeal chamber does not agree with the appellant's contention that the trial chamber denied the appellant the right to present a full defense and to be provided with a reasoned opinion. The appeal chamber emphasizes that the detailed records of trial chamber site visit should normally be kept. The purpose of a site visit is to assist a trial chamber in its determination of the issues, and therefore it is incumbent upon the trial chamber to ensure that the parties are able to effectively review any findings made by the trial chamber in reliance on observations made during the site visit. However, the appeal chamber finds that in this case, the appellant has not demonstrated that he was prejudiced by his inability to challenge the trial chamber's observations, and that the parties had the opportunity to make arguments based on their observations of the site visit in their closing arguments and closing briefs, to which the trial chamber referred in its judgment. Accordingly, the second ground of appeal is dismissed in part. As previously noted, the remaining arguments presented in the second ground of appeal have been considered together with the seventh ground of appeal relating to the events in Rusash. Under the third ground of appeal, the appellant chiefly submits that the trial chamber erred in finding that before his formal appointment as prefect of Kigali Prefecture on 17 April 1994, he exercised at least some of the authority which would normally have been exercised by the prefect. For the reasons given in the judgment, the third ground of appeal is dismissed in its entirety. In his fourth ground of appeal, the appellant submits that the trial chamber erred in its assessment of the evidence of certain witnesses relating to his alleged involvement in MR&D in Nyarugenge after 92, and in finding that he exercised authority over the Interahamwe in 1994. For the reasons given in the judgment, the appellant's fourth ground of appeal is dismissed in its entirety. In his fifth ground of appeal, the appellant claims that the trial chamber erred in its factual findings in relation to his involvement in a campaign to kill Tutsis in Nyamirambo sector, Nyarugenge commune. In essence, the appellant submits that the trial chamber erred in finding that he exercised authority over 3 policemen involved in the killings, and that a number of Tutsi persons were murdered as a result of orders to kill Tutsi, which he gave to both Interahamwe and the policemen who guarded his house. In support of his claim, the appellant has submitted a number of arguments that are considered in detail in the judgment. For the reasons given in the judgment, the appeal chamber grants the appellant's fifth ground of appeal in part. In particular, the appeal chamber reverses the appellant's convictions for ordering genocide and extermination and murder as crime against humanity based on the alleged murders of Kahabaye, Dingutse, and Nyagatare committed in Nyamirambo. In this regard, the appeal chamber finds as follows. The trial chamber erred in convicting the appellant based on the murder of Joseph Kahabaye. The appeal chamber finds that no reasonable trier of fact could have concluded beyond reasonable doubt that Kahabaye's murder was a consequence of an order to kill Tutsi given by the appellant. Since the evidence relating to the location of the crime and the identity of the perpetrators was not corroborated, and in fact remained conflicting. The appeal chamber further finds that the trial chamber failed to specify the link between the murder of Kahabaye and any specific order given by the appellant. Accordingly, the appeal chamber grants the subground of appeal and reverses the appellant's conviction for genocide and extermination and murder as crimes against humanity based on this event. The trial chamber erred in convicting the appellant based on the murder of Ndingutse. The appeal chamber finds that no reasonable trier of fact could have accepted the uncorroborated hearsay testimony of witness BMU that the policemen who killed Ndingutse were the policemen who guarded the appellant's house. Furthermore, no reasonable trier of fact could have concluded on the basis of this circumstantial evidence that the only reasonable inference was that Ndingutse had been killed pursuant to the appellant's order to kill Tutsi. Accordingly, the appeal chamber grants this subground of appeal and reverses the appellant's conviction for genocide and extermination and murder as crimes against humanity based on this event. And the trial chamber erred in convicting the appellant based on the murder of Nyagatare. The appeal chamber finds that no reasonable trier of fact could have found that the only reasonable conclusion available from the circumstantial hearsay evidence presented by the prosecution was that Nyagatare was killed as a result of the appellant's general order to kill Tutsis in Nyamirambo. The appeal chamber finds that the trial chamber did not err in finding that between 8 and 10 April 1994, police officer Kalimba forced a man to kill Murekezi, a Tutsi, at the roadblock near the appellant's house, and later boasted that he had carried out the killing following the appellant's order. However, the appeal chamber, proprio motu, has considered the question of whether the trial chamber erred in using its findings that the appellant was responsible for the killings of Joseph Kahabaye, Murekezi, Jean Bosco Ngutse, and Palatin Nyagatare in support of the convictions it entered under count 1 of the amended indictment for genocide and under count 3 for extermination as a crime against humanity. The appeal chamber invited the parties to address this issue at the appeal hearing. The appeal chamber has already quashed the trial chamber's finding in relation to the killings of Kahabaye, Ngutse, and Nyagatare for other reasons. Therefore, it need only consider whether it was permissible for the trial chamber to convict the appellant for genocide and extermination as a crimes against humanity based on the murder of Murekezi. The appeal chamber notes that the allegation of the murder of Murekezi is only made at paragraph 33 of the amended indictment in support of count 4 for murder as a crime against humanity. In Muvunyi, the appeal chamber observed that, I quote, the prosecution's failure to expressly state that a paragraph in the indictment supports a particular count in the indictment is indicative that the allegation is not charged as a crime, unquote. The appeal chamber considers that the same may be said where a certain allegation is charged under a particular count only. In the present case, the amended indictment put the appellant on notice that the prosecution was charging him for the murder of Murekezi only under count 4. There is some basis for argument that by reading the amended indictment alone, the appellant would not have understood that he was also charged for the same fact under counts 1 and 3. In regard of the amended indictment, the prosecution knew the identity of a finite number of victims and was able when it sought to amend the indictment to specify the circumstances of their murder. It chose not to list Murekezi's killing in the statements of fact pertaining to the counts of genocide and extermination as a crime against humanity. The appeal chamber recalls that even in cases where a high degree of specificity is impractical, since the identity of the victim is information that is valuable to the preparation of the defense case, if the prosecution is in a position to name the victims, it should do so. With regard to the prosecution's submissions that the amended indictment has to be read as a whole, the appeal chamber notes that while the statements of facts supporting count 4 incorporates the statements of fact supporting counts 1 and 3, the reverse is not true. The statements of fact supporting counts 1 and 3 do not incorporate the statements of fact supporting count 4. This lack of reciprocity might have added to the impression that Murekezi's murder was not incorporated in counts 1 and 3 of the amended indictment. The appeal chamber further notes that the process of amending the initial indictment might have caused confusion on this issue. Originally, Murekezi's killing was listed in a statement of facts pertaining to both counts 3 and 4. However, this statement of facts was eventually severed, and Murekezi's killing was subsequently mentioned only in the statement of facts applicable to count 4 of the amended indictment. While the rationale for the severing of the original combined statement of facts did not center on Murekezi, the amendment may have given the message that Murekezi's killing related only to count 4 of the amended indictment, rather than serving as a basis for the gravest of the charges involved, namely genocide and extermination as a crime against humanity. The appeals chamber considers that the prosecution's decision not to refer to Murekezi at all in counts 1 and 3 of the amended indictment, especially in the context of the indictment amendment process, resulted in vagueness with potentially serious consequences for the preparation of the appellant's defense. In these circumstances, the appeal chamber considered that the reversal of the affected convictions is appropriate. The appeal chamber further notes that the amended indictment was issued on 19 December 2005, 7 days after the filing of the prosecution pretrial brief. As a result, while the pretrial brief included a summary of anticipated witness testimony, the text of the pretrial brief and the summaries included only references pointing to either the indictment or the draft amended indictment annexed to the prosecution motion to amend the indictment, but not to the amended indictment itself. Turning to the prosecution's contention that the pretrial brief presented the factual allegation by location, including the Amirambo, rather than with respect to each count, the appeal chamber does not see how this argument is capable of demonstrating that any defect in the amended indictment relating to the facts underlying counts 1 and 3 was cured by the prosecution pretrial brief. Appellant's counsel might have focused more attention on Murekezi's killing had this key material fact been more specifically linked to a larger number of counts concerning crimes such as genocide and extermination as a crime against humanity, which on their face appear more serious than murder. Instead, the amended indictment may have given the opposite impression. This error and the confusion it might have generated justify reversal of the appellant's conviction under counts 1 and 3 insofar as they rely on the murder of Murekezi. Accordingly, the appellant's conviction for genocide and extermination as a crime against humanity based on the killing of Murekezi are quashed. In his sixth ground of appeal, the appellant challenges his convictions based on his alleged involvement in an attack on Tutsi refugees at Ntarama Church in Kigali Prefecture. For the reasons given in the judgment, the appeal chamber finds that the appellant has failed to demonstrate any error in the trial chamber's findings in relation to this attack and accordingly dismisses this ground of appeal in its entirety. In his first, second, in part, and seventh ground of appeal, the appellant challenges his convictions based on the events in Rushashi commune. For the reasons given in the judgment, the appeal chamber grants the appellant's first ground of appeal and reverses the appellant's conviction for aiding and abetting genocide and extermination as a crime against humanity, insofar as they are based on the alleged weapons distribution in Rushashi commune. The appeal chamber notes that the amended indictment referred to two incidents of weapons distribution, both of which concerned location other than Rushashi. The appeal chamber considers that the prosecution post-indictment communications, which referred to weapons distribution specifically in Rushashi, in effect expanded the charges contained in the amended indictment by adding a new incident of weapons distribution at a new location. The appeal chamber is of the view that this constitutes a de facto amendment of the amended indictment, which is impermissible. Accordingly, the appeal chamber finds that the trial chamber erred in holding that as a matter of law, the prosecution's post-indictment communications could cure the failure to include the allegation of the Rushashi weapons distribution in the amended indictment, and that they, in fact, did so. The appeal chamber also grants the seventh ground of appeal in part and reverses the appellant's conviction for instigating murder as a crime against humanity based on the killing of Gakuru. The appeal chamber finds that on the basis of the trial chamber's factual findings, the trial chamber could not have reasonably concluded that the appellant prompted the perpetrators to kill Gakuru. The trial chamber made no factual findings supporting such a conclusion. It merely concluded that the appellant had informed the Interahamwe, who later killed Gakuru, that he was an Inyenzin and ordered them to arrest him. The trial chamber should have further explained how, on the basis of these factual findings, it inferred that the appellant had prompted the Interahamwe to kill Gakuru. In the absence of such an explanation, the appeal chamber accordingly finds that the trial chamber erred in convicting the appellant for instigating Gakuru's murder. However, the appeal chamber upholds the appellant's conviction for aiding and abetting murder as a crime against humanity based on the killing of Gakuru. By instructing the Interahamwe to arrest Gakuru and telling them that Gakuru was an Inyenzi, the appeal chamber considers that it was reasonable for the trial chamber to conclude that the appellant substantially contributed to the commission of his murder through specifically assisting and providing moral support to the principal perpetrators, and that in light of the evidence adduced, he had the requisite mens rea. The appeal chamber also upholds the appellant's conviction for instigating and aiding and abetting genocide and extermination as crimes against humanity based on his participation at meetings in Rushashi commune, where he raised money for weapons, encouraged youth to join the Interahamwe, and urged the commission of crimes against Tutsis. For the reason given in the judgment, the appeal chamber further finds that the appellant has not substantiated his allegation that the evidence of his participation in pacification meetings is incompatible with evidence that he was involved in the killings in Rushashi and Nyamirambo. Under his 8th ground of appeal, the appellant has raised a number of arguments related to his alibi and contends that it was impossible for him to be present at the various crime scenes considering the distances between the sites and the conditions of the roads. For the reasons given in the judgment, the 8th ground of appeal is dismissed in its entirety. Under his 10th ground of appeal, the appellant has raised a number of arguments related to the trial chamber's legal finding, which in fact challenge the trial chamber's factual findings. Since the appeal chamber has already addressed these arguments in the respective sections of the judgment, and in light of the fact that no additional arguments are presented under this ground of appeal, the 10th ground of appeal is dismissed without further discussion. In his 11th ground of appeal, the appellant submits that the trial chamber erred in law by hearing the case of Tarsis Renzajo, the former prefect of Kigali, while it was deliberating on the appellant's case. The appellant alleges an appearance of bias on the part of the trial judges. He submits that a reasonable observer would have concluded that quote, that the deliberations of the trial chamber in the present case were tainted by its hearing of the Renzajo case, unquote. For the reason given in the judgment, the appeal chamber dismisses the ground of appeal. The fact that the trial judges heard the Renzajo case while at the same time they participated in deliberations on the appellant's case does not in itself demonstrate an appearance of bias on the part of the trial judges. In his 12th ground of appeal, the appellant submits that the trial chamber committed an error of law in sentencing him to imprisonment for the remainder of his life. The appellant claims that the numerous errors of law of fact that affect the trial chamber's findings are such that the trial chamber should have acquitted the appellant and the sentence should never have been imposed on him. In the alternative, the appellant argues that the trial chamber should have imposed a reduced sentence and requests that the appeal chamber substitute the current sentence with an appropriate sentence. Third, the appellant submits that the trial chamber did not take into account the factors it should have considered in determining the sentence. To this end, the appellant points to factors that, according to him, should have mitigated his sentence but were not considered by the trial chamber. That is, the pacification meetings, which he held in Rushashi, his efforts to ensure the safety of Vincent Muniandamutsa, a well-known RPF supporter, the time, 13 months, spent in detention awaiting judgment during the trial chamber's deliberation, and the fact that as he is being sentenced for the remainder of his life, the appellant is not in a position to benefit from the reduction of the sentence granted by the presiding judge during the delivery of the trial judgment. Article 24 of the statute allows the appeal chamber to affirm, reverse, or revise a sentence imposed by a trial chamber. However, the appeal chamber recalls that trial chambers are vested with a broad discretion in determining the appropriate sentence. This stems from their obligation to tailor the sentence according to the individual circumstances of the accused and the gravity of the crime. Generally, the appeal chamber will not substitute its own sentence for that imposed by the trial chamber unless it has been shown that the latter committed a discernible error in exercising its discretion or failed to follow the applicable law. The appellant made no sentencing submissions during closing arguments. In such circumstances, the trial chamber was not under an obligation to seek out information that counsel did not put before it at the appropriate time. The appeal chamber further finds that in pointing to the pacification meetings in Rusashi and to his alleged efforts to ensure the safety of Vincent Munyandamutse, the appellant merely presents factual assertions without showing how the mitigating circumstances were undervalued by the trial chamber. Therefore, the appellant has not demonstrated that the trial chamber committed a discernible error in its assessment of the individual mitigating circumstances. The appeal chamber considers that in sentencing, the trial chamber correctly took into account the gravity of the offenses and the degree of liability of the convicted person, the individual circumstances of the appellant, and his role in the crimes, including any mitigating circumstances, as well as the sentencing practice of both the tribunal and Rwanda. It found it appropriate to impose the maximum sentence. The appeal chamber recalls that even where mitigating circumstances exist, a trial chamber is not precluded from imposing a sentence of life imprisonment where the gravity of the offense requires the imposition of the maximum sentence provided for. Mindful of the gravity of the appellant's crime, the appeal chamber does not find any discernible error in sentencing. Turning to the appellant's claim that the trial chamber erred in sentencing him to life imprisonment when the charges against him were not proven beyond a reasonable doubt, the appeal chamber recalls that it has upheld a number of the appellant's grounds of appeal. The appeal chamber has also reversed several of the appellant's convictions, namely for aiding and abetting genocide and extermination as a crimes against humanity based on the alleged weapons distribution in Rusashi commune, for ordering genocide and extermination and murder as crime against humanity based on the alleged murders of Joseph Kahabaye, Jean Bosco Ngutse, and Palatine Nyagatare, and for instigating murder as a crime against humanity based on the murder of Gakuro. In addition, the appeal chamber, proprio motu, has reversed the appellant's convictions for ordering genocide and extermination as a crime against humanity based on the killing of Murekezi. Therefore, the remaining question before the appeal chamber is whether it should revise the sentence imposed by the trial chamber in view of the findings made in the appeal judgment. The appeal chamber considers that the crimes for which the appellant remains convicted on appeal are extremely grave. They include genocide and extermination and murder as crimes against humanity. These crimes resulted in the death of a large number of civilians. The appeal chamber has considered the mitigating and aggravating factors discussed by the trial chamber and concurs with the trial chamber that the aggravating factors outweigh the mitigating factors. The remainder of the appellant's arguments in respect of the sentence are addressed in the judgment. I will now read out in full the operative paragraphs of the appeals chamber's disposition. Mr. Karera, will you please stand? This is the disposition. For the foregoing reasons, the appeal chamber, pursuant to Article 24 of the statute and Rule 118 of the rules, noting the written submissions of the parties and their oral arguments presented at the hearing on 28 August 2008, sitting in open session, allows the appellant's first ground of appeal and reverses the appellant's conviction for aiding and abetting genocide and extermination as a crime against humanity based on the alleged weapons distribution in Rushashi commune. Allows in part the appellant's fifth ground of appeal and reverses the appellant's convictions for ordering genocide and extermination and murder as crime against humanity based on the alleged murders of Joseph Kahabaye, Jean Bosco Ngutse, and Palatine Nyagatare. proprio motu reverses the appellant's convictions for ordering genocide and extermination as a crime against humanity based on the killing of Murekesi. Allows, in part, the appellant's seventh ground of appeal and reverses the appellant's conviction for instigating murder as a crime against humanity based on the murder of Gakuru. Dismisses the appellant's appeal in all other respects. Affirms the appellant's conviction for instigating and committing genocide during the attack against Tutsi refugees at Ntarama Church on 15 April 1994. Affirms the appellant's conviction for instigating and committing extermination and murder as crimes against humanity through the killing of Tutsi refugees at Ntarama Church on 15 April 1994. Affirms the appellant's conviction for ordering murder as a crime against humanity based on the killing of Murekesi. Affirms the appellant's conviction for aiding and abetting murder as a crime against humanity based on the killing of Gakuru. Affirms the appellant's conviction for instigating genocide and extermination as a crime against humanity based on his alleged conduct at meetings held in Rushashi Commune between April and June 1994. Affirms the appellant's sentence of imprisonment for the remainder of his life, subject to credit being given under Rules 101D and 107 of the rules, for the period in which the appellant was deprived of his liberty for the purposes of this case, that is from 20 October 2001. Rules that this judgment shall be enforced immediately pursuant to Rule 119 of the rules, and orders in accordance with Rules 103B and 107 of the rules that the appellant is to remain in the custody of the tribunal pending his transfer to the state in which his sentence will be served. Monsieur Karera, veuillez vous rasseoir.
Mr. Karera, you may be seated.
Je demande maintenant au greffier de...
I'll now ask the registry to distribute the copies of the judgment to the various parties of this case.
Je vous remercie.
I thank you.
Nous levons à présent l'audience de la Chambre d'appel.
We have come to the end of this session of the appeals chamber.